for a long time in this jurisdiction, going way back, we've been handling a volume that is much higher than anywhere else in the country.
If you're on the bench all the time, you're likely doing something wrong.
If you open a door and the judge isn't on the bench, it doesn't mean that the judge isn't hard at work. How many times have you had someone submit a request for an order shortening time to get a hearing on an emergency basis within a few days?
Oh, every day.
It's frequent. You get them every day.
Several every day.
Extension.
And you respond to all of our emails.
I respond to a bunch of emails, yes. and I put out small fires.
Yes.
Because there's
Sometimes
always something.
big fires.
There's always something going on.
I'm Stacy Rocheleau. I am sitting in Department W in the Family Court.
I am Dee Butler. I am sitting in Department J.
I'm David Gibson, Jr. I'm the presiding family court judge sitting in Department L. Today we're going to talk about the family division, what we do, where we come from, and what we're about. The three judges we have here today, between the three of us, we cover all of these specialized and general areas of family court within the family division. The family division was created in 1991 in Nevada by statute. NRS 3.0105 describes the creation of the family division. Not all the courts throughout Nevada have a family division, just those counties that have 100,000 people or more. The judges we have here were elected to serve the public in that capacity, and we wanted to talk a little bit about what we do on and off the bench as your judges. I think the perception out there is that all the work a judge does is robed up and sitting behind a bench and above everyone else with the gavel. If anyone wants to throw in about what your typical day is like. Judge Butler is currently hearing delinquency cases. Juvenile delinquency as juvenile justice. So what's a day like for you, Judge?
Thank you, Chief Judge Gibson. A day in juvenile delinquency, there's a lot of preparation that starts. I typically go into the calendar and I have to review all the filings, the history of the case. So that's one thing as judges we do a lot, and I'm a very early morning person because I would like the facts to be fresh in my mind. So I'll jump up sometimes 4, 5 o'clock in the morning and review the case. And then once the calendar starts, it really just goes and goes in juvenile delinquency. So our calendar starts in the morning and we hear cases for juveniles in our community that have unfortunately been charged with offenses that would be crimes if they were adults. And we hear from probation officers, the district attorney, the defense counsels, whether private or public defender. We hear from their families. So one case can be really involved and take a long time. And we generally have full calendars that go through lunch, typically past the lunch hour. And so it's a really full day. Then if we get a break, great. But we typically do our contested hearings, which in the juvenile delinquency division, that's the trial. Of course, all minors, our youth, are entitled from the Constitution. They have a constitutional right to a trial. We call that a contested hearing. So we hear those in the afternoon. And then we have our certification hearings for children where the state is seeking to transfer them to the adult court based on serious, heinous, egregious offenses. So it's typically a very long day in juvenile delinquency court. And then after that, we have to kind of debrief, take our notes, and there's orders. For instance, if there's a certification hearing, don't want the child to be waiting. So then I have to go do the order for certification, and that could take a little while as well. So it's a lot of work. And as my colleagues know, typically if we aren't working on evenings and weekends, there's no way that we can do this job successfully.
Yeah, with delinquency, I think that's a good point that you raise. A lot of the orders that you have to issue are time sensitive and require your immediate attention. For instance, a certification decision, which is a weighty decision in and of itself. You're deciding to send a child to adult court and by extension to adult incarceration. They have their own wing at CCDC, but what a lot of people don't understand about juvenile delinquency is the child doesn't have a right to bail. And so they are held without bail, and so the proceedings necessarily need to move as soon as possible and as quickly as possible to dispense justice for that child and hopefully get them out of a detained situation if possible. But when a child is certified, the court no longer has jurisdiction of them. And so it's important that that order be completed immediately so the child can be transferred. And once the child's transferred, that does trigger the right to bail and the potential to be released either on their own recognizance or different things like that. So that's just one aspect that I don't think is always taken into account with how you're on all the time, right? Yes. And Judge Butler's courtroom would be one of those that if you just popped in at any random day at any random time, you likely would see a judge on the bench because that's just the type that it requires. Judge Rocheleau has a split docket. She's pioneering that. That was my brainchild. I think it's working out in a way that I can expand it among the bench. And so what I'd like to do, because all of us are very qualified to hear a number of different types of cases, and I think that the public deserves to have the best minds on the bench and hearing things. But her days go a little different, right?
My days are much different, especially with the split docket. So what a split docket means is that I have 50% is civil domestic, which is custody, divorce, paternity, cases like that. And then 50% of my caseload is guardianship. And guardianships, I do minor guardianships, not adult guardianships. Minor guardianships are for children whose parents are unable to care for them. Not so much that they fall into the abuse and neglect category, which Presiding Judge Gibson, there is a little crossover there, though. This is more when a family member steps up. Well, a parent can disappear, or a family member just comes in, a grandparent, an aunt, an uncle, sometimes a sibling comes in and says, hey mom, hey dad, you have some things going on in your life, an employment history, substance abuse. Why don't we take the child for a while? Or mom or dad says, hey, I'm having some issues in my life, can you help me out? And so a third party comes in and takes guardianship over that child, cares for them, provides for them, feeds them, education, and until that parent is, we call it restored to suitability, meaning that they can then step back in as their parent and care for them. The crossover comes with the dependency when CPS does remove the child, but then there's still a third party willing to take that child. Sometimes a relative, most times a relative, sometimes not, so that they don't have to go into foster care. So with the minor guardianship, so we have an initial citation hearing, and that's by statute, has to be held within so many days, especially a temporary guardianship if there's an emergency that exists, immediate medical attention or some other emergency. Those have to be heard within 10 days of giving a temporary guardianship. We look at the child. The child always has the right to an attorney. So we contact Legal Aid Center of Southern Nevada, and they graciously provide attorneys that are appointed for the children. They meet with the children, talk with them, find out what their preferences are, how they're doing, and then they bring them to that citation hearing. And minor guardianship is one of the ones where the children actually come to court. We get to see them, which is actually great. I love the kiddos, but they're not in not such good circumstances, right? I mean, their family unit is breaking apart. This third party's coming in. Sometimes it's someone that they don't really know very well. A lot of times, though, it is, a grandparent or an aunt or an uncle will come in. So my guardianship days actually start before the day begins, and I, unlike Judge Butler, am not I am an early riser, but for different reasons. Rather than getting up for work, I get up and go to the gym. But so I don't start, 4 or 5, 6 o'clock in the morning. But I do mine the day before. So I prepare for our hearings the day before. There's a lot of orders that I have to prepare prior to coming to court, because when the guardian is there, I like to give them all of their documents, their orders, their letters, their consents, anything they need. I have a packet of information along with that order, and I prepare that in advance so that I can give that to them there. They don't have to come back to the courthouse. They don't have to wait for it in their mail or the email. They have it there. So I prepare all of that in advance. So we have our citation hearings. We have sometimes parents come in and want to terminate the guardianship because they believe they've been restored to suitability. Sometimes they are, sometimes they're not. Sometimes we have competing guardianships where, maternal grandmother who is, mom's mom wants the children, or dad's mom wants the children, the paternal grandmother wants the children. So then we have to hear those contested guardianship hearings. We have, for the children that have estates, where a parent or someone has died and left them money, life insurance, we have to hear those. We have to do annual accountings. So there's a lot going on in guardianship alone. And then I have a civil domestic calendar, which I hear motion hearings for anything that deals with divorce or custody. We also have trials, both with guardianship and with the civil domestic, divorce trials, custody trials. So it's a full calendar, I will say, and the guardianship caseload is a lot. It's a lot. So yeah. I appreciate Judge Gibson's brainchild because it's challenge. It's interesting. It's a high caseload though. It's a lot. It's a lot of work.
Yeah, I gotta say, I really appreciate Judge Rocheleau. I mean, I really appreciate Judge Butler as well. I was in the delinquency case type for a bit, and I know what that requires. Along with Judge Rocheleau, Judge Throne, Judge Duckworth, and Judge Gentili oversee all of the guardianships between adults and juveniles in Clark County. Their caseload is massive. The other thing that's interesting about the guardianship end is it's highly structured at the state level in terms of the types of findings that you must make, the number of enumerated categories and considerations under the statute that you have to take evidence on in order to accurately adjudicate it. And it's an area of law where there was a lot of reform done at the state level. And over the years, it's been a hot button area of the law. And so it's really helpful to have some very experienced practitioners who were very experienced practitioners in their practice now sitting in those and hearing those types of cases as well. And they do a great job. I don't know how they fit it all into the hours of the day, honestly. From my perspective, I'm the presiding judge, and traditionally, a presiding judge took a 50% caseload reduction. I didn't think that was very fair to the other judges when I was appointed, and so I kept my full caseload, which at that time was a delinquency caseload, and then the retirement of an older judge, one of my mentors, Frank Sullivan, opened up the possibility of the calendar that I now sit on, which is just because of its nature, reduced in size. So it served the purpose of giving me, to some degree, some case reduction so that I could spend the administrative time I have to do as the presiding judge. But it's a very trial-heavy case type. I hear dependency, which is children that are dependent on the courts and the state for their safety. Abuse and neglect is the kind of common reference to that case type, and my caseload involves children who are 5 years old and under, children that can't typically speak for themselves, can't typically tell you exactly what happened to them, and so the physical evidence that I'm presented with is ripe for argument between the lawyers that represent parents and the lawyers that represent the state. We very frequently have to have a trial proceeding, and I have to find places in my calendar for it, typically the evidence is disturbing because it does involve physical abuse of children of that age. I also handle mental health decisions regarding children that are committed to a mental health institution by the state. I have to have a weekly calendar where I am overseeing what's going on with those children in our system. And then I also run a specialty court, which is our family treatment court for parents that have drug abuse issues. That is a court that's been around for some time. We are making some changes there. We're turning that court into what's called the Safe Babies Court. It's another specialty. It focuses on children 3 and under, and it's a kind of case that the judge has to sit on frequent status checks to see how the family's doing and things. So what appeared to be a reduced caseload hasn't ended up being one, but I'm happy to pull as much weight as I can. I have considerable weight, and I need to pull it. And our domestic judges, and Judge Rocheleau was only able to touch on that for just a moment, but all three of us have sat a general domestic calendar, which is the bread and butter of family court. It's the main issue that people associate with the family court: divorce, division of marital property, child support, spousal support, custodial considerations, domestic temporary protective orders. Those are all within the exclusive original jurisdiction of the family court. And that was granted under NRS 3.223 when the family divisions were created. So a family court judge is a general jurisdiction judge, but we have added powers that we're responsible for with exclusive original jurisdiction under the statute in a variety of case types that we've kind of touched on here. There are a few more. The statute enumerates them, but that's what the family court deals with. A question that was asked was, how do judges' workloads impact their ability to competently preside over cases? When I saw that, and I saw that word competently, my immediate reaction was, we all have to be competent. There's no excuse for a lack of competence. When you have put yourself out there, when you have run for a seat, when you have put yourself forward as a judge, the promise you made to the public when you did that was that you would be competent to serve in the jurisdiction that you serve in. That being said, we all come from a wide variety. Judge Butler, you came from a criminal defense background, public defender, right? I grew up in a public defender's home. I always have a special, spot in my heart for public defenders. Judge Rocheleau was a partner in a very successful family law firm in general practice too, right?
Mm-hmm. Mostly family, though.
Mostly family, but a number of attorneys in your firm. I was a solo practitioner, but a general practice as well. Handled some government contracts, but also practiced family law, criminal law, and civil law. And I think that among our judges, that's what you'll find really is a variety in background. So as far as competency goes, the public should expect nothing less than that we are competent. I think where our caseloads really impact us is in timeliness. Right. That's my impression. Right. In our ability to deliver the product that we are supposed to deliver to the public in as short a time frame as possible while still making a good decision.
Right.
Either you want to talk about how your large calendars impact timeliness or what some of the timeliness requirements of your calendars might be, because I think all three of our specialties do have statutorily required timelines involved in certain things.
So, I will just say, with especially guardianship as a very high volume caseload, and we're all human, right? We only have so many hours in a day. Just because you put on a robe doesn't mean you now get 30 hours in a day. It's still the same 24 hours, and you have to try to manage all of those cases while giving each case the attention that it deserves. And some need a lot more attention than others. And, when you have such a high case volume, it does, if you don't give the time and attention that it deserves, there's a risk of errors, right? Mm-hmm. We have very highly factual intensive cases. There's a lot of facts going on with these families, a lot of dynamics that we need to learn and read about and understand. And if you don't know those, then you might make an error of fact. If you don't learn the law, new cases that are coming down, new statutes, then you might make an error of law, because you have to do all of that work before you make the decision. And so I think the timeliness does really impact it, because you don't have all that time that you want to dedicate. And then you have to take time to write the decision, right? To make the decision and to write up the decision. And if you delay in that, then, there's a delay.
Other consequences.
There's other consequences. Right now you're delaying, the relief for the children or for the families, and there could be financial loss. But if you make a rushed decision, which none of us do, right? But if you don't have the time to do it timely, and it's the best product that you could give, well, then if there's an appeal, then there's a remand. and then there's more frustration, and then there's more stress, and then there's more impact on these families. And I mean, I don't want to say, justice delayed is justice denied, but on either hand, there's delay. If you want to and need to take the time and serve these families correctly, you need to put in the time. Yeah. I always say it's like, you're a football player, right? You can't just go into a game and play,
Right.
It's the time off the field that makes you a good player and helps you succeed on the field. And that's kind of like off the bench. Mm-hmm. If we don't put in the time off the bench, we can't do good for the public on the bench.
Yeah.
It's true. And it's so many issues that are related. I want to focus on the fact, as my colleagues have talked about, is that these are such weighty decisions, even on the domestic cases, because I am fairly new to juvenile delinquency. So I have domestic cases that I'm finishing, and that's because they are some of the most difficult cases where parties who are no longer married, they're dividing businesses. They were married for 30 years. So of course you're talking about alimony. So for each, our orders are getting longer and longer, like 30 to 50 pages sometimes, because we have to follow the instructions, the findings per statute. And then also we have to review the cases that are coming out of the Supreme and Appellate Court. Law is always changing. So we could literally be in the middle of a decision, and then a decision comes down and we're like, okay, now we have to add findings and go back and look at that. So when there's a domestic case that's a divorce, I want the public to understand that a lot of thought goes into these decisions. When there's children involved in its custody, it's the best interest of the child standard. So there's factors that we have to go through. And typically when there's a trial, we're looking at plaintiff, defendant, we're reviewing the pleadings and the hearings to decide on each side which factor favors which. And then that's only one topic sometimes on a case. Then there's also alimony, more factors. Then there's also, for instance, if a parent wants to relocate, that's a different statute with different factors. If one side requests attorney's fees, that's a different statute with different factors. So it's not just sitting down at a desk and making a decision. There's a lot of work. A lot of these cases go on for months, unfortunately, a lot of motions, other hearings where we've made temporary orders. So we have to go back and make it all make sense. And it's a lot of work. And I know a lot of us go back and review our hearings, and we want to make the right decision. We want to get it right. I think anyone really wants to get the smackdown from the appellate or Supreme Court, but we're doing it for the families in our community. We want to have efficient orders, and we want families who are particularly in divorce matters for this to be as painless as possible generally. Regarding the caseloads are really, really high, and I think each of us have different styles, and you just have to learn, because it's easy to get behind. I know when I was a domestic and first started, we have many pro se litigants who are representing themselves. They don't really want to, or when they submit an order, it may not be correct. So I would do all the orders for everyone representing themselves. Well, then I still have to do the decision. So like I said, it's a lot of work. Yeah. And I think we have to learn, as a newer judge, I was just elected in 2020, there's trial and error, and you just have to learn what works and what doesn't work so that you can get the best decision as effectively as possible.
Yeah, I lucked out. Before I took the bench into Department L, I had served as a hearing master for 6 years, hearing abuse and neglect cases. And 432B is the statute that governs most of juvenile dependency, and there are very strict timelines that we have to abide by, and it's also high volume. We, at any given time, have about 2,000 kids in care, sometimes even more, and each of them, or each small sibling group, represents a case, and that's currently spread between 6 different judges. But our caseloads, as far as current open cases, tend to mirror what our domestic colleagues have in terms of numbers. What is not understood, I think, in the general public about family law specifically is there isn't just a start, a middle, and an end to a case. It's just a start and a middle and an end to the particular controversy involving those people at that time. A dependency case very frequently comes back over and over again, and we see people with multiple petitions and multiple removals of different children at different times. Juvenile delinquency is very similar. Some of these young kids, unfortunately, are carrying upwards of 10, 12, I've seen as many as 20 petitions in their youth. So every case that we newly open each year, until all the kids involved turn 18, it is always sitting there with the potential of coming back. So though we may all be carrying anywhere between 300 and 500 open pending matters at any given time, there are thousands of matters that each of us are carrying that could reopen at any given time. And that's what's really unique about the family bench. My particular approach to the volume that I deal with, I was able to hone that as a hearing master because I had these timelines that I had to be on, and so you get really good at speed reading. You get really good at finding the times of the day where you can prep and budgeting when you need to start getting ready for a future calendar. Every hearing that I hear is supported typically by at least one report that will vary in page length from 15 pages to 250 pages. And on today, Wednesday, any given Wednesday, I'm going to hear 19 of those or 20 of those where I will have had to consume a report for each of those. And so when you start to think about that, when you're thinking about 500 to 1,000 pages, we're talking about 2 reams of copier paper full of information that you have to digest. You have to have it in the front of your memory and be ready to speak with knowledge about what's going on with that particular family, and then you have to make a decision, and then you have to dump it out and move on to the next case. And those are skills that you pick up as a lawyer along the way. They're skills that you hone as a judge, but it's difficult sometimes to take in all the information that we have to base our best decisions on. Oftentimes we are victims of our own success. For a long time in this jurisdiction, going way back, we've been handling a volume that is much higher than anywhere else in the country. There was a weighted caseload study done in 2005. At that time, there were 12 judges. And that study, which was done by a nationally recognized organization, compared us to other urban areas. And at that point, they made the determination that we were underserving in our public with judicial resources, that we didn't need 12 judges, we needed 21. That was 2005. The population in this valley, anybody who's lived here for any amount of time knows that it exploded. We didn't reach 20 judges until 2016 in this jurisdiction. In 2019, there was another study done. They re-examined what was going on in the family court. They found that the Clark County Family Court, that our time to disposition was faster than most every other similarly situated jurisdiction. They found that our appeal rate was lower than almost any comparable jurisdiction. They found that we are still operating on far too few judges. At that point, they said, we could have justified, I think, about 12 to 15 more. The legislature gave us 6. So we finally hit 26 judges in 2020. We have recently this year done a follow-up study using the same criteria as the weighted caseload study. And we determined that we are easily about 12 judges short again at this point. So we're constantly playing keep up, but we're also continuing to get our dispositions done and get decisions for the people in Clark County done at a rate that is faster than any other comparable jurisdiction. The problem with that is at some point you're going to reach a breaking point. Our district has been laboring with too few judges for far too long, and then you have to make a decision. Do I take even more time on the case, or do I keep hitting these benchmarks that we've set for ourselves year in and year out? And it can lead to a lot of exhaustion, I think, a lot of frustration on the part of judges. But we all signed up for it, so we do it. As far as the general jurisdiction goes, paternity actions, divorce actions, unmarried custody actions, abuse and neglect proceedings, and things like that, the public probably doesn't understand completely the difference between those things. So maybe we can unpack that a little bit. One thing that I noticed as far as unmarried custody action and a paternity action, those are actually one and the same statutorily. Traditionally, in our jurisdiction, we created a custody case type, but it truly is a paternity action. And that's led to things that have bitten us recently, right? Because the statute automatically closed paternity actions. Most of what we're hearing are custody actions, but they truly are paternity actions. Luckily, the Supreme Court is now giving us some guidance on opening those things up to the public and how we can give the public more access to it so that they can understand it better. But I think each of our case types do have types of hearings that really are presumed to open, even in abuse and neglect, which is highly confidential. Half of the hearings that I hold are presumed to be open to the public, and I've always pursued them that way. The public is welcome to come into my courtroom at any given time. If I happen to be hearing a matter that is presumed to be closed, I explain that to the member of the public, and I let them know when my next open one is. I haven't had a lot of visitors lately, though, but the people are certainly welcome to come down and see what I do. Judge Butler, yours are
We're
quite
open. We are open.
You're just wide open, right?
I mean, there's this Falcone case. So we're going to close a hearing. We must make findings. And typically we try to close it in the least restrictive way. So of course, if there's sensitive information, severe abuse, sexual abuse in our cases, we'll protect the child and explain why. But typically the courts are wide open.
Yeah, I have to be careful with some of mine because some of the information that we deal with on a daily basis is protected by statute, and it's technically a gross misdemeanor to release it to the public. And so that's when that comes up. So, none of us want to break the law either. So we're kind of always, wanting to pay attention and closely, I think we'd all agree though that, the public being able to see what we do is a good thing. The public having access to the courts is a good thing, and I think most of our judges agree and welcome the guidance of how to ensure that the parts of their courts that can be open are open versus those that are closed.
All of the minor guardianship cases are open. None of those are sealed, so they're open. And again, just like with dependency, I have a lot of confidential information that I have to read before and that goes into these cases. So again, we walk that fine line with all of that. But yes, they are all open. The only cases that I see that are presumptively by statute closed are the termination of parental rights and the paternity cases. But no, just like Judge Butler said, we have a list of factors, more factors that we have to make findings on. And, we appreciate the guidance because it gives us a checklist, right? What is the Supreme Court looking for? What does the law require? So we have our checklist, and then we look at and examine each of those factors. So we do appreciate the guidance.
And if I can just interject, there is an intersection. I was just thinking about that as we were all speaking of our discipline. So there's family court, then we're talking about domestic and juvenile and guardianship. But then also, like you said, Chief, we have our specialty calendar. So on the typical day, today is a Wednesday, like dual ward. So there's a specialty dual ward calendar where we have youth who have a case in delinquency court, but also are in the dependency court. So this is a specialty calendar where we hear those children's special needs. We're usually dealing with mental health issues, but children who have a background of child abuse and neglect. So it's a lot when you break down the time that we have per day, like also in delinquency. So on Monday, I only hear in the mornings JSO cases, so children that are charged with sexual offenses. And then in the evenings, again, trials and cert hearings. Then I have a general calendar on Tuesday. Then I have a dual award calendar on Wednesday. Then a general and certification calendar on Thursday. And then Friday will be left over for trials or maybe can work on a decision. So I want people to understand that it's a lot more than I was aware of before taking the bench, but it's all in an effort to provide the community with the best service on the different issues.
Yeah. The other thing that's interesting about our case type is you don't only have to keep up with family law. Most of these families, they're real families. They are in their community. They have other issues that are impacting them. They get into car accidents, right? They, some of them commit crime. They have people sue them from time to time. And a lot of those factors, so we may not adjudicate all of them, they still become relevant in the determinations that we make sometimes. When a father has criminal trouble, the mother may use that as grounds to seize custody from him. For good reasons, if it's true, right? But I remember several cases when I was practicing as an attorney that started out as dependency matters, but morphed into a criminal case, into a custody issue. I had several clients who I was serving in 4 different courts all at the same time. And that's the thing about family court is it's a huge melting pot for everything that's going on in a typical person's life if they're a member of a family. And so we have to stay, all judges have continuing education requirements and things like that, but it's already been alluded to. We are repeatedly receiving direction from both the appellate court and the Supreme Court that may change the way that we do things from time to time. I've had a recent decision come down from the Supreme Court that completely changed our approach to certain relationships that exist in dependency actions. And though I applied the law as it had been applied for the previous 20 years, it changed. And so now I have to apply the law in a different way. And, I always welcome that. I always welcome direction from the court above. If they want me to do it in a different way, I'll do it in a different way. But I think the biggest quality that each of us really has to work on is decisiveness. The biggest complaint I ever had as a judge, as a lawyer, was when I couldn't get a decision out of a judge, right? Where in my highly structured area right now, I must deliver a decision very quickly, and so that skill served me well when I had a domestic calendar because I was used to making a decision. I also got into the habit in cases where parties were represented of making the attorneys in front of me prepare my order once I delivered the order. That tended to speed things up for me. But at the same time, there was a question here about editing software and different things that we have available to us. I can tell you there are plenty of family court judges who exclusively write their own decisions rather than entrusting that duty to the attorneys before them, or as Judge Butler stated, with a self-represented litigant. From time to time, they might be relying on an outdated form. They might be relying on bad advice from someone else. Yes. I've had plenty of arguments made about sovereignty and other things like that were taken from a pamphlet somewhere, and sometimes in order to make sure that their rights are preserved, you have to take the responsibility yourself within your department. And we have things that help us do that. We all have law clerks who can do research for us, who can brief cases for us, who can at least get the framework of a decision into a computer that we can then edit from there. Family law requires that we include actual statutory notices to people in a lot of our orders, and that's something that a law clerk can put in for us. But the meat of the decision is always ours, and we have different approaches as to how we get it down on paper, but there isn't any single one that is not time consuming, because even when I rely on an attorney in front of me who prevailed to write an order, I'm frequently having to issue an order to show cause as to why they haven't filed something with me yet. So I end up doing that decision myself a lot of the time anyway. So I think that it can't be lost on any observer of family court that if you open a door and the judge isn't on the bench, it doesn't mean that the judge isn't hard at work and isn't working with a number of other people to try to dispense justice as quickly and as correctly as possible.
Well, certainly, and I think you tell us all the time as a mentor for us younger judges that if you're on the bench all the time, you're likely doing something wrong because trials should be resolving. We offer settlement conferences. We try really hard to get parties to resolve. We try to do a lot of decisions on our papers. We do decisions by minute orders to get them out quicker. We are signing, hundreds of orders in the orders app throughout the week. So I truly want the public to understand that as well, that there's prep in the morning or evenings, but there is a lot of time off the bench. And then we'll have random things happen. Just a quick little story. I was in a trial on a juvenile case yesterday, and it took a very long time for the attorneys to let me know that this was being continued. A witness was missing. But then we get a call from the district attorney's office that they have a child that's in detention on a mistaken identity. Just found out it's a different kid. This kid had a detention hearing that morning. The DA's office is asking to have an emergency hearing to have this kid released. Absolutely. Mm-hmm. Absolutely. I mean, that's the best thing that could happen, but we have to get all the players in place. So I'm calling someone from the public defender's office. Where's defense counsel? And now we need probation. Oh, we have to call detention and get the kid brought over. Let's call the parent, who got there in like 5 minutes, by the way. But we do have really beautiful stories and moments like that. But it's those random impromptu things that happen in family court that we really just can't explain. I don't even know if we talk about those stories enough.
How many times have you had someone submit a request for an order shortening time to get a hearing on an emergency basis within a few days?
Oh, every day.
It's frequent. You get them every day.
Several every day.
The other things that just, pop up on you, it's incredible. And yeah, you have to be flexible. Each of us serves a duty as well where we're on call 24 hours a day, 7 days a week for a period of a few weeks to review applications for temporary protective orders.
Yes.
That duty rotates through all of my judges. As the presiding judge, I am a backup on all of those. And then I also have my own warrant duties that I do a couple of weeks at a time every month. For removal of children from a home. And then any district court judge can be approached for a criminal warrant as well. And so that's the other thing that I don't think is seen as much as in the hours that we're off the bench. I'm currently on duty for warrants today as the primary. But as a presiding, I'm also very often the backup or the third backup or both. Technically I am on call almost every day of the year, 24 hours a day. And all of our judges serve significant amounts of time throughout the year where they are on call 24 hours, 7 days a week. And I don't think that's something that's really talked about that much, that we don't, because it's just part of what we do. The thing about being a judge is once you're elected, you are always a judge until you aren't anymore. So we have, I don't know how often it crosses your minds, but judicial ethical considerations, ex parte communication. Someone knows you're a judge, they are bound to try to approach you at some point, either through social media or in public, if you're a face that's known in your community, those kinds of things. And we have to be on guard for that all the time as well. And so there's so much more to the judge, to the role of a judge, and I think Judge Butler did put it really well. And I do say this to my family court judges: if you're on the bench all the time, you might be doing it wrong. We have a type of law that I think demands that people still have the power to make their own decisions for themselves. Mm-hmm. And so I think each of us, probably in our domestic caseload, very frequently encourage families that are in conflict to try to put that conflict away, at least in the best interest of their children, to come to a resolution of as much as possible. When you need me to make a decision for you things have gone wrong for you. I will make the right decision when it comes to me, and I will do that. That's my duty. But I would much rather have you figure out your problem on your own and sign the order that gives it legal effect, rather than have to sit and split the proverbial baby in half. It's not. That's an aspect of our job that I think is difficult.
Yes.
And sometimes we can come off as callous, right? When we do make a decision, rarely is anybody satisfied with the decision that you've made.
Yeah, right.
But we have to make a decision.
Yeah.
And sometimes it may appear that it's choosing a side, but we are going through all of the factors and weighing in favor of which party throughout.
Yeah.
Right. And, goes to your point, Judge Gibson, when you said, we encourage them to come to a settlement. That's another part of our duties as a judge that people may not know about is we volunteer to do settlement conferences. We're a part of a settlement conference. I don't know if they do that in dependency or in delinquency, but certainly for our domestic calendars, we volunteer once a month. We volunteer to do settlement conferences for other judges' cases. So not on our own cases, but on,
For each other.
For each other, so that we can assist our fellow judges and the litigants, the families, to see if we can bring them to conclusion. So that's something else that we do. And that requires, again, I have to review the file, right? I want to be an informed settlement judge. So I need to know the dynamics of that family. I need to know the financial considerations. I need to know what's going on to settle your case, right? What's going on?
Yeah.
What needs to be
Well,
resolved?
To some degree, you need to know that case better than the judge that case is in front of, because they
Perhaps,
haven't heard the evidence yet, and they have to remain impartial.
Right.
But if you're serving as the person who's trying to help the parties settle, you hear all the hearsay. You hear all of the stuff that might not come in on the record, and then you go back and forth between those parties to try to help them find the way to something they can stomach, right? Something they can agree upon.
Yeah.
And give them insight sometimes as to what their judge might do.
Right, exactly, because we may know the judge better than they know the judge, and to say, or even if we don't, say, but as a judge, this is where I see it going to go. This is not as relevant as you think it is, or this will not be admissible in court. We try to encourage them to come to an agreement. And you're right, we probably do end up knowing that case better than the trial judge.
Well,
Most of them are really successful. It is a
successful program.
We do have a very high
rate.
success rate with our judicial settlement program. It's somewhere north of 80%.
Right.
And so we do. And one of the questions we had was, do we help each other out? Do we talk to each other about cases and things? We're limited in what we can talk about. The ethical rules, require us to remain not only impartial, but prevent us from doing independent investigations and different things like that. However, we are all officers of the court within the same court, and we are ethically allowed to spitball or workshop with our colleagues in generalities sometimes, some specifics, as long as we don't give parties' identities away and different things like that. But we will come to each other from time to time, because there is a vast amount of experience on our family court bench. We have one judge who's been there right from the start. Art Ritchie's been on the bench forever. And he has a wealth of knowledge that he's willing to share with younger, less experienced judges. He's also been a chief judge before, and so he has an administrative outlook that I rely on from time to time. I'll call Judge Ritchie up and say, hey, this is what I'm facing right now with this management problem. How did you handle that? And I think, from even our newest judges, they're not that new anymore. Judge Butler, you've been on the bench for nearly 6 years now. We have a few newly appointed judges, and we do try to mentor our newest judges with judges who have some experience, so that they have someone that they can speak to. Because the other thing about being a judge is it's a very lonely job. The decision is yours to make, not anybody else's. The information that you hear, you're not able to respond very frequently when you get a question. Why did you rule that way on that case? Well, if that case is still in the appellate process or anything like that, and you comment on it, you could lose your position as a judge. So, as open as we want to be, there are rules that force us to not be as open as we would like to be sometimes. There was a question about the difference between a chief and a presiding judge that I guess I'm the one that can answer that.
That's you.
Essentially, the chief judge is elected by all of the sitting district court judges between the family division and the general division. And that is a judge who serves for a period of 2 years as our chief, and can serve a second term of two years, but is then limited in the terms that they can serve. They can order other judges to do things. That's my best description of the chief. He's literally the chief. As a presiding judge, I preside over the family division, which is one of 2 divisions within our general district court, but I'm an extension of the chief, essentially. I am, for lack of a better word, at best, first among equals. All of the judges that I serve with, I don't serve over. I am, however, an extension of the chief in that he can delegate authority to me and ask me to take care of certain administrative duties. He describes my duties by way of an administrative order, pursuant to a rule change that we got through a few years ago. And so my duties are strictly defined by the administrative order from the chief. That's who I report to. I serve on an executive committee. It handles the administrative side of things in our court. There's basically two layers of authority in the court. It all is capped by the chief. He's in charge. But then he or she will rely on other judges named as presiding judges of different types of case types. They serve on an executive committee, and that committee, along with the court executive, who is an employee of the court but is the chief executive of the court, then handle the issues of the court. The executive handles HR and different things like that, the day-to-day function of our clerks and our administrative marshals, those kinds of things. The executive committee, of which the chief executive is a member, we make decisions governing the entire court. But down through the presiding judges, what we do is we let our fellow judges within our case types know what the chief wants us to do. We make recommendations on caseload assignments. We make recommendations on specialties and different things like that, which judges fit in those areas the best. I conduct a monthly meeting of the judges where we handle some in-division type business and things like that. But and then I liaise with our court administrator in the family division. We have 2 of them. We have a general domestic administrator and we have a juvenile administrator. And in concert with them, I weigh in on the HR and administrative side of things. But for the most part, that's delegated to them. So that's the real difference. I'm a family court judge. That's what I am. And then I have some decisions that the chief asks me to make, and so I do them. I take marching orders from the chief. I'm not elected by my fellows. I'm appointed by the chief, and my authority is derived from the chief. So I'm just an extension.
And you respond to all of our emails.
I respond to a bunch of emails, yes. and I put out small fires. Because there's always something.
Big fires.
There's always something going on. And then my door is also always open to my colleagues. I've been on the bench since 2012 between my time as a hearing master and as a district court judge. And some judges think I have enough experience to give them some advice now and again, and some don't. So, and there are other judges in our division that have more time on the bench than I do. And I speak with them about things that I might not know the answer to. So that's kind of how that works. Do any of you utilize sidebars? There was a question here about what a sidebar or a conference in chambers might look like. I never have conferences in chambers.
But
the only thing that I've had is say before a trial starts, a counsel they'll tell the marshal, can we have a few words with the judge before we get started? So I'll say, sure. What's up? And they'll say, and usually it's because they've been out front talking to see if they could resolve the case, and they're stuck on one issue or more. So I will go out and speak with them, and here's what my thought. Here's my thought. What are your thoughts? And they'll say, well, I haven't heard the evidence yet, but based on what I've seen through the case and through the pretrial memorandums, if there's nothing more than that you're going to show me at trial, this is where I'm leaning.
Yeah.
They
And
say,
the slick ones try to corner you on certain ideas now and again, right? If you utilize the
maybe.
sidebar. For me, when I saw that question, a sidebar is really a creature of the jury trial environment.
you're right.
I think a sidebar is typically off the record, outside of the hearing of the fact finder. In family court, something unique about us, we don't have juries. We are the fact finder, the judge is. And so a sidebar with a judge doesn't serve the same function that it would in the general division, where there might be something that could affect the jury's decision or be misconstrued. You would approach the judge or go back to chambers to discuss a legal issue or something along that line. In the times that I have had discussions off the record with counsel, I'm very particular that any counsel, and then any self-represented litigant who might be in front of me if the other side has counsel is included in the conference and the discussion, so that we don't enter into any ex parte communication.
Chief, I think is good to mention, because sometimes I'll have sidebars. Sometimes counsels will request sidebars because there's something to be discussed outside the presence of their clients, because they're really trying to get a solution and want to know what we're going to do, or in the juvenile case, just sensitive information and just want to get the judge's idea on if we're leaning this way and we want to resolve, what do you think we'll do? But the important thing is we still have to follow rules. So what's tricky about sidebars are everything is supposed to be on the record. So I have to be really careful, and we all do, to when we come back in, we have to then make a full record of everything that we've talked about in the sidebar, or we should be trying to do that. And it's really hard to remember everything, but I know for counsels, they want to make their record, and they should for appellate reasons. So that's the tricky thing about sidebars.
It's not truly a sidebar for us, I think. When the fact finder is involved in the sidebar, and then the fact finder is a judge. I think you're right. And it's a prudent practice when you come back onto the record to, at a minimum, at least summarize for everybody there what was discussed and what the conclusion of it was. And frequently when I have people approach, they usually are going to ask me about whether or not a late produced document might still be considered, or if a rebuttal witness that wasn't listed could still be called, or different things like that. I always like to get as much admissible evidence as possible, and so when I have questions like that, I'm pretty free with my discussion with the counsel. I'm like, yeah, I would consider that if it were moved in. I will certainly consider an objection, and I'll make a ruling on it. But there are some things that are done off the record that a lot of it too is, I don't know how many times I have people ask, can we handle some preliminary issues before we get going? They might have settled some of it. We might be focusing the issues that are going to be heard on the record that day. Sometimes it actually has, how much time do we have today, Judge? And can we get everything in that we need to? I know there was a question about whether we can handle non-family court cases or not. And yes, we can. The chief would typically assign us if that were the case. From time to time too, in smaller jurisdictions throughout the state, there may be an issue where the judge, maybe the lone judge in that jurisdiction, just can't hear it because of conflicts and things like that. Sometimes those get sent down to us to be heard as well. But it's typically doled out by the chief. And then I was saying off camera before we started that my courtroom is the only courtroom in the family court building that has a jury box. It was built that way so that if we do have to decide an issue that required where there's a jury right, we could potentially impanel a jury there. But I think honestly what we would do nowadays, since there's 6 of us downtown in courtrooms that already have jury boxes, we'd probably just
give all those cases to
them.
No, that's not
Since
the way it works.
got big case loads,
I'll trade you courtrooms today, because I'm at the RJC at the Regional Justice Center, and yes, so I do have a jury box, and also Judge Throne is just down the hall from me, so she has a jury box, and you can make a demand for jury trial in a domestic case, and she has had one, and it settled right before it went to trial, but no, you can absolutely demand a jury.
It's certainly within our discretion to grant it.
Yes.
I wouldn't
as long
ever,
as
I
you
don't think.
timely make your demand pursuant to the rule.
You have to make your demand in time. You've heard us talking about some of the challenges of being a judge, but I always wanted to be a judge. When I went to law school, on the first day of law school, they asked us, where do you see yourself in 15, 20 years? I said, on the bench. If I wanted to be in a courtroom, I wanted to be arguing, I wanted to be making a case. I had no stomach for contract law or anything along that line, which is funny because so much of family court is contract law. But I always wanted to be in the courtroom. I grew up in a public defender's home. I went to work with my dad. I was exposed to courtrooms at a very early age. Some people might have thought that was bordering on, bad parenting, but it wasn't. I grew up idolizing members of this legal community. I grew up knowing a lot of judges who have now since retired, and I always wanted to be one. So I love my job. I love being a judge. I don't like presiding as much as I like being a judge because it does require me to do things outside of a normal judicial role from time to time, and I didn't necessarily sign up for it, but when the chief called, I said yes. So there you go. But I just thought, what do you guys think about being a judge?
I love being a judge, and I actually, and I've done domestic for probably my entire career, right? And so I love domestic. I love the families. I love the children. I feel like I'm making a difference. And so when I transitioned to be a judge, you look at a judge, and the only exposure you have is in the courtroom, right? You see them up there, they're asking questions, you're listening, they're listening to your arguments, and they're making a decision. So what I didn't realize was that's a small part of what a judge does. And so I was just blown away and it took me a couple years to figure it all out, to know that there is a lot more to being a judge than just sitting in the courtroom. And I think maybe it was you, or maybe it was the chief that says, if you're sitting in the courtroom the whole time, you're doing it wrong. And I think another way that you're doing it wrong is because you're not serving your families. Because if you don't know that case before you come in, then you can't ask the right questions, and you can't listen to them, and you can't give them the time that they deserve. But I love being a judge, and I love the split docket, because now that gets me into it splits up my week, honestly, because like Judge Butler, I have different days for different things. Guardianship day is all day Wednesday and half day on Monday and Tuesday evening, Tuesday afternoon, and so I split them up, so it's a nice balance, I think. So
I love being a judge. Love being a judge, particularly in juvenile delinquency, which is funny because our presiding here asked me to go over to juvenile delinquency, and I just did not want to leave the domestic cases. I didn't.
Yeah, I asked a couple of times.
I did not want to leave my domestic case. I'm like, how do I leave in the middle of all of these domestic cases where I've got to know the families? Because like you said, I have a different style. So a lot of my cases have a lot of status checks for high conflict issues. I've gotten to know the kids. My teenage interviews. So it was really, really hard. I'm still doing domestic cases. And I will still volunteer for the domestic settlement conferences as well. But juvenile delinquency, I love it. And maybe there's a good reason why you're here, Judge Gibson, because Judge Gibson came to me, and I just think my background works so well. I had no idea I even wanted to be a lawyer. Definitely did not think about being a judge. But life just takes us on a journey sometimes. So as a public defender, as you know, we're in court all day. So we get to know our track judges very, very well. And then I became team chief in the public defender's office for the domestic violence track. And we were certainly in court all day. So we had more intimate relationships with judges. It was actually some of my judges I've peered before that encouraged me to go out and run. And I'm happy that you did. You are. But I really enjoy the job, particularly working with kids. Our kids are going through a lot in our communities. I will say I started, full circle moment, I started in the juvenile public defender's office, appearing before Judge Voigt in courtroom 18.
oh wow.
And now I am in courtroom 18, hearing cases. So a lot of the probation officers and people have been around a very long time. So it's almost like very familiar coming back home, but the case types are so different. When over a decade ago, we would see cases of, school fights, threw chocolate milk across the lunchroom, and now, unfortunately, a lot of the cases are more violent, gangs and firearms and that sort of thing. So I believe I'm in a position to actually help our youth in the community here, and definitely great decision by our presiding.
No, that highlights it. This case type takes a toll. Yes. It does take a toll on the people that are hearing the case, that are making the decision. And so, that's another thing that we might not get credit for from time to time is the resilience on the bench that we have. Sometimes, especially in abuse and neglect, I have to look at evidence that stays with you, and so it's important to have a work-life balance as a judge as well. We do have to have downtime, and sometimes you feel like you're criticized for the downtime that you take, because it might not be understood that for every hour that we're on the bench, we're probably putting 2 to 3 in preparation, and that's really the curtain being pulled back on what judges do, what family court judges do is, and I think I appreciate the forum here today to talk about it, to get that information out to the public that we are working very hard, and many of us have set a very high professional standard for ourselves. As Judge Rocheleau repeated a couple of times here, she wants to be prepared when she puts the robe on and steps up and sits in the chair. And that preparation is expensive in time, in personal time. You have to do a lot of reading. You have to do a lot of preparation. And then once you've made your decision, you've got to tidy up after yourself. So it's a demanding job, but the 3 judges we have here, I think all of us represent the general sentiment of our family court that we enjoy serving the public, and as hard as it is, it's also very worth it. There was one question we didn't get to, and it was a very specific question about protective orders, as far as what does it take for one to be granted a domestic violence protective order, and then what actually has to be proven. You could probably do a panel on that on its own, but at its basic, for a temporary protective order to issue, there has to be a qualifying relationship, which is defined by the statute, a qualifying familial relationship, domestic relationship, and then there has to be a qualifying event. And those are also enumerated in the statute. There's a number of them. If both of those 2 things exist, at least for a temporary protective order, it should be issued. They are ex parte in nature. They're applied for by an applicant. Very frequently, the respondent only finds out about it when they're served with a copy of it at the jail, or outside of the jail when they get out. There is very typically an arrest that's happened on a lot of the ones that we review, where more evidence is heard then is when the protective order is extended. When the party is seeking to extend it, that return hearing that's 7 to 10 days after it issues, that's where more evidence is heard, and where more scrutiny to the credibility of the witness and different things like that would come into play on whether or not you're going to continue to deprive somebody of some very basic constitutional rights for a longer period of time. Hearing masters hear those original ones live for us. Judges review those applications after hours. And then the hearing masters that we utilize, they are then subject to a de novo review by a supervising judge. And so each of the protective orders that come into the family court are assigned to any one of the 26 judges, essentially. And then if there's a need for review or a need to scrutinize it more from an evidentiary standpoint, then it goes up to the judge. So it's just yet another thing that's one of the things that we do. So I wanted to kind of make that clear. We do utilize hearing masters in the division, primarily for high volume child support cases, and also our high volume live temporary protective orders. And then 2 hearing masters work for our 2 delinquency judges to handle the misdemeanors and different things like that, and some of the detention hearings and things. So we use them in ways that are authorized by statute. They have limited power, and it's all reviewable by a judge.
Right.
I think
there was a question about if there's a no contact order, but the contact you want to make is nice or a gift.
Yeah,
you want
yeah.
That was a very interesting.
I think that's in another panel that's coming. I think that's in another panel
Okay.
that's coming up. We did see some of those questions as
that
well.
question.
Maybe I
But,
read ahead.
But yeah, no, we apply the law as it's written and as it's been interpreted by the Supreme Court and the appellate court. And that's something that I think also is from time to time. Judge Butler did a good job earlier on talking about the different elements that have to be met for us to make a decision. And for each of those elements within the statute, we have to receive evidence for it. And, we see a variety of talent amongst our self-represented litigants and our represented litigants in presenting a case. And the decisions that come out of the family court ultimately are only as good as the information that we're able to take in. So we do the best that we can with what we have. Have faith in the family court. We are working hard. We do our best to make good decisions. And when we get it wrong, there's somebody watching and they let us know. And we usually adjust and adapt and move forward.
Yes.
Thanks for letting us serve. Thanks for letting us have this opportunity here today to tell you a little bit about what we do.
Thank you, D. Butler, Department J, Family Division of District Court. Thank you to our community for supporting us. Thank you for listening if you've gotten this far. Thank you for inviting us out to community events so we can be involved in that way as well, and know that we are trying our best to make the best decisions for families in our communities.